Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Um, how do you like my new headphones? I have new headphones with new mics, so hopefully you will be able to hear me crystal clear with what I have to say. If not, let me know. Today we are going to talk about visitor visas. A lot of people from the world come to the United States on a visitor visa. And a lot of people misconceive what the visitor visa is supposed to be used for, what can be allowed on it, what can't be allowed on it, and so forth. So I thought I'd clear up a few of the misconceptions. I thought I'd clear up a few of the paths that need to be taken in order to get the visitor visa, and then we'd be able to go from there. So the visitor visa is generally referred to as the B1 slash B2. Now, why B1 slash B2? Well, the B2 part of it is specifically what is meant by visiting. That's the B2. The B1 is more for business. Now, it's just right off the bat, B1 doesn't mean you come to the U.S. and work. Okay, that's for a U.S. company. That's not what it means. B1 generally you get a lot less time in the U.S. than a B2, and it's like basically to go to conventions, to negotiate contracts, and I mean contracts with your company outside the U.S. And to find personnel to come to your company outside the U.S. and so forth. There's also people sometimes get a B1 for the purpose of starting an E2 company. Basically, the way that it works is that the the B1 normally will be issued for between 30 to 90 days. And you come here, do what you need to do for the business purposes, and then you leave. I've had clients come in and say, well, they came in on a B1 and they worked and everything's fine, but it's not fine. If you work on a B1 minus some narrow exceptions, you are working without status and you are violating your status. We could talk about the B1 in lieu of H1B. That's a little bit of a different issue, and there's some issues whether or not it's still actually in effect. But essentially, when the H1Bs are all used up, it is a possible path that can be taken in lieu of the H1B. Now, for the B2, I mean, the bottom line is you come on a B2 to go visit Disneyland, to go have fun with your family, to visit friends, to travel. That's the purpose of a B2. The B2 is not to come in to get a job. It's not to come in to marry. It's not to come in to become a lawful permanent resident. Now, everything is intention. That's really what it all comes down to. That is the bottom line. So if you get a B2 and your intention is to come and marry your longtime boyfriend and apply for residency, that would not be permissible. Now, let me give you an example. Some people come in on a B2 on, let's just say, June 1st, and then come, June 20th, they're married to a U.S. citizen. Well, the law says that if you come in on a visitor visa and within 30 days you get married to a U.S. citizen, that's fraud. That's absolute fraud, meaning that there's no way that you intended to come and visit Disneyland. What you really intended was to come in and get married and obtain residency. So, if those people decide they want to go through and try to adjust status to get the green card for the person who came in on the B2, not only will it be denied, it'll be denied and the person will be placed into deportation proceedings for fraud, most likely. Now, same scenario, except let's say that you get married between 30 and 60 days. Well, in that particular regard, there is a rebuttable presumption of fraud. Now in this case, at least you have the opportunity to fight the allegation that you've committed fraud. So let's say you really did come in to, go visit Disney World, and while you're at Disney World, you madly fell in love with a U.S. citizen, or your longtime girlfriend, who you intended when you entered to remain your longtime girlfriend, something happened, and boom, you magically decided to get married. So that's how that works. Now, of course, if you get married after 60 days, there is no fraud or rebuttable presumption of fraud, but still they can test your intention and question your intention upon entry. Now, when you come on a B2, many times people will come to me and they'll say, well, I've been here for 4 months and it expires in 2 months. Can I get another extension? Well, if you came to me before 2001 and said that, I would say no problem. It's a piece of cake. We just fill this out, send it in, and get 6 more months, no problem. But the last few years have changed, okay? And whereas it used to be very easy to get an extension of a visitor visa, now it's the exact opposite. And now I will basically recommend anything else other than trying to get an extension. So, and the funny part about it is when you apply for an extension of a visitor visa, the visitor status, by the time you get the denial, you're already way out of status of the time that you would have been allotted anyways. So, and unless there's some critical reason that you need to extend, there's 99% of the time another way around it. So, for example, that same person who came into my office that wants to extend their visitor stay, I find out, number one, they may go to school so they can change to an F1. Many people will have degrees, and so I can say, look, you can get a H1B. Many people already have businesses in their foreign country, so then we go for an L. A lot of people have money to invest in their own company here, and they come from a treaty country, so we can go to an E2. Some people have churches that want to sponsor them. They can go to an R1. I mean, it's alphabet soup. You can do all kinds of stuff other than try to extend the B2. Now, here's an interesting tidbit. When you go into the consulate, the consulate and the law, this is what the law says. It says it presumes you do not want to come back to the foreign country, to your country, once you're done with your stay in the U.S. So you have to prove to their satisfaction that you are intending on going back to your home country once you're done with the visit. So essentially, written in the law is guilty until proven innocent, and that's just the way it is. So when you go there, you need to bring your assets, copies of your assets, of your jobs, of your ties to your home country. You need to bring all kinds of information to prove that you intend on going back to your home country. That's the hardest part of getting the visitor visa. You can have some nice letter from some relative saying you're just coming there for 2 weeks for a wedding and that's all, but that's not going to be sufficient. You will also have to prove you have the financial resources in which to not have to get a job if you don't need one. Now, if you're on a visitor stay. Now, there is a distinction many times with some countries. They say, well, we don't need a visitor visa. We can just come for 90 days and leave. And that's referred to as the visa waiver. So when they come in the U.S., they get the card and it says WB, which is a visa waiver for business, similar to a B1, or the WT, which is a visa waiver for tourists. Now, if a country has less than a 2% rate of people who don't go back when they're supposed to, then there's agreement with the U.S. that, it's a reciprocal agreement that they don't need to formally apply for a visitor visa. So, for example, a U.S. citizen wants to go to France. They don't need a visa. All they need is their passport. They fly to France and boom, 90 days they can stay there, have fun, go on the bullet trains, do whatever they want. And likewise, from France, they can come to the U.S. and tour the country for up to 90 days and then leave. So the reason for that is, policy-wise, at least it's easier for the people, the citizens, just to go back and forth when they want to. But when you have countries that have a high rate of not, people who violate their status and they don't return, such as Mexico, China, Philippines, India, a lot of those types of places, there's no way that they're going to get a visa waiver, at least under the present law. So they will need to apply for the visitor visa. Now, a visitor visa, there's no derivative benefits, meaning that, for example, let's say you get an H-1B, okay, work visa. Well, you get an H-1B, that means your spouse gets an H-4, your children under 21 and married get H-4s. Everybody gets an H-4 basically, and you get the H-1B. It's no problem. But with a visitor visa, with the B-2, you are the only one that gets the B-2. So if you want to come to the U.S. with your spouse likewise has to apply for a B-2. If you want to come with your child has to get a B-2, your spouse has to get a B-2, you have to get a B-2. There is no derivative benefits. So if you have been denied the B-2, a lot of it could be what you said, at the interview. They might have asked one question. They might say, why do you want to go to the U.S.? And you might say, well, I want to visit my long-term boyfriend. Well, boom, be denied in a second. In a second, because they know all you have to do is get married, get the adjustment, and you're not coming back. So that's the way it is. So there's lots of alternatives to the B-2 if you can't get in. But if you are dead set on getting the B-2 on the visitor visa, there are ways of making the B-2 packet a lot nicer, okay, a lot more attractive, a lot more probability of success. We put the declarations, affidavits, exhibits, financial exhibits, the attorney cover letter, and all that. So, give me a call if you'd like to learn more about the B-2, and we'll go from there. More on the coming videos.